Hey guys, welcome back to our YouTube channel. Today we are going to discuss labor law. So, welcome to the discussion of legal aspects of hospitality management, and today's discussion will focus on just cause and authorized cause of termination of employment. So, pag-uusapan natin ngayon kung ano yung kaibahan ng authorized cause at yung just cause, kasi pwedeng magtanggal ng empleyado ang isang hotel o restaurant o kahit ano pa mang tourism enterprises, okay, as long as valid yung reason ng employer. Alright, so today's short video lecture, okay, is actually based on Department of Labor and Employment. So we're going to use their question and answers, okay, to different concerns. So we got this from their website. Alright, let's start with what is the right to security of tenure. So every one of us is, of course, aiming for security of tenure. So gusto natin ng security. So kailangan natin ng trabaho, gusto natin na regular tayo dun sa trabaho natin. So security of tenure, ibig sabihin yung hindi ka agad-agad maalis dyan. So meron kang aasahan. So yan, the right to security of tenure means that a regular employee shall remain employed unless his or her services are terminated for just or authorized cause and after observance of procedural due process. Ibig sabihin, hindi tayo pwedeng basta-bastang alisin ng ating employer. So as long as dapat valid yung reason niya at kailangan the employer should observe procedural due process. So everyone should be accorded with due process. So there is a lecture video here, okay, discussing due process clause. So we have it under Article 3 of Bill of Rights. We have it under Section 1. Alright, so number 2. May an employer dismiss an employee, and what are the grounds? The answer is yes. So like with what I said earlier, an employer may dismiss an employee on the following just causes. So please take note of these, guys. These are the just causes. Okay? Letter A, serious misconduct. Letter B, willful disobedience. Letter C, gross and habitual neglect of duty. Letter D, fraud or breach of trust. Letter E, commission of a crime or offense against the employer, his family or representative. Letter F, other similar causes. So if you can notice, all of the causes are actually coming from you. So the negligence will be on your end as an employee. So ibig sabihin, ikaw mismo yung may gawa ng dahilan kung bakit ka maaalis. Maaring late ka lagi pumasok, maaring absent ka ng absent, maaring nakagawa ka ng hindi maganda doon sa kumpanyang pinagtatrabahuan mo, maaring nag-violate ka ng isang rule o ng ilang mga rules, okay, doon sa kumpanya, kaya ka tinanggal. Okay? Let's proceed to number 3. What are there other grounds for terminating an employment? What are they? Yes, the second ground is considered as authorized cause. Letter A, installation of labor-saving devices. So halimbawa, nagdagdag na ng mas maraming computer, okay, yung kumpanya, okay, kaya nagdagdag ng maraming makina o devices, instead of employing 200 employees, they reduced it to 150 because some of the functions can be already automated, can be done by machines or devices, by the technology. So that is a valid reason. Letter B, redundancy. So example, okay, sa kumpanya, napakarami ng accountant na nag-handle ng accounts receivable. So masyadong doble-doble na yung post. Okay? Isa lang din naman yung trabaho. So pwede siyang bawasan, alisin. Okay, lalo na tinitingnan na dito yung performance, okay, ng empleyado. Kung ire-retain ba yung empleyado o hindi? Letter C, retrenchment to prevent losses. So example, this pandemic. So, nung nagsimula ang COVID-19, okay, yung iba talagang pinipigilan nila na mag-retrench. Ibig sabihin, magbawas ng empleyado. Okay, pero dahil nga masyado nang tumagal, yung ibang kumpanya nagsara, ay yung iba huminto ng operation, so kinailangan nilang mag-retrench, okay, magbawas ng tao. So katulad nung nangyari sa mga airlines natin, okay, may mga eroplano, mga kumpanya na nagbawas sila ng kanilang mga cabin crews. Okay, kasi syempre wala namang lipad o nabawasan yung mga bilang ng flight, okay, ng mga eroplano natin. Ganun din sa hotel. Okay, may ilang mga hotel kung saan makikita ninyo na napakarami nila dating food attendant o food servers, pero ngayong pandemic makikita mo isa o dalawa na lang yung naka-duty. Ibig sabihin, nagbawas sila. Okay, dahil wala din namang kinikita masyado yung hotel. Okay? Letter D, closure and cessation of business. So ito yung pinakaayaw nating mangyari, na kapag nagsara talaga ang negosyo, walang magagawa yung empleyado kasi talagang mateterminate yung employment niya. Kasi syempre, yung negosyo mismo ay hindi na nakayanan na makasurvive. Letter E, disease or illness. Of course, kapag namatay ka na o nagkasakit ka, maari ka nang tanggalin sa trabaho. Okay, lalo na kung ito ay permanente o pangmatagalan talaga. Pang-apat, before terminating the services of an employee, what procedure should the employer observe? An employer shall observe procedural due process before terminating one's employment. So we have a lecture video on this, the difference between the substantive due process and procedural due process. So sa pagkakataong ito, ang kinakailangan natin, obserba, ay yung tinatawag na procedural due process. Kasi hindi tayo pwede na agad-agad o basta-basta na magtatanggal ng empleyado. Pandima, what are the components of procedural due process? In a termination for just cause, due process involves the two-notice rule. Letter A notice of intent to dismiss specifying the ground for termination and giving said employee reasonable opportunity within which to explain his or her side. So, the employee has the right to be informed. So, you have to inform the employee. So, through a written notice, kinakailangan yon. Hindi pwede na sinabihan mo lang siya. Letter B, a hearing or conference where the employee is given opportunity to respond to the charge, present evidence, or rebut the evidence presented against him or her. So, kaya nga sinasabi natin, sa discussion natin ng procedural due process, kailangan present ang notice and hearing. So, yun yung dalawang elemento na kinakailangan na makita, okay, kapag ginagawa o sinasagawa yung procedural due process. Okay, notice and hearing. Kailangan written notice, kailangan mabigyan ng pagkakataon na madinig ang panig ng bawat tao o panig. Pangatlo, a notice of dismissal indicating that upon due consideration of all the circumstances, grounds have been established to justify termination. Right? So, by the way, kung kayo yung empleyado na nagtatrabaho sa hotel, kayo yung nasa Human Resources Department, kailangan documented kayo lahat. So, hindi pwede na hindi documented yung hearing ninyo. Okay? So, that is part of the procedure, kaya nga may minutes yan. So, lahat ng mga sinabi, lahat ng mga pag-usapan ay kailangan nakasulat. Alright, in a termination for an authorized cause, due process means a written notice of dismissal to the employee specifying the grounds at least 30 days before the date of termination. A copy of the notice shall also be furnished the regional office of the Department of Labor and Employment where the employer is located. Okay. Number 6. What is the sanction if the employer failed to observe procedural due process in cases of legal and authorized termination? In cases of termination for just causes, the employee is entitled to payment of indemnify or nominal damages in a sum of not more than 30,000 pesos as per case of Agabon versus NLRC. In case of termination for authorized causes, 50,000 pesos, like in the case of Jaka Food Processing versus Darwin Pakot. So by the way, guys, may mga example na dito, mga case digest. You can find time to read the cases cited in our discussion. Okay, you can search them online, right? So by the way, we have a separate video for damages. All right, I'll explain to you what are the different kinds of damages. Okay, how are you going to indemnify a person? So yun, nakabukod siyang video, guys. So I hope you'll be able to watch that video. Number 7, may an employee question the legality of his or her dismissal? The answer is yes. The legality of a dismissal may be questioned before the labor arbiter of a regional arbitration branch of the National Labor Relations Commission or NLRC through a complaint for illegal dismissal in establishments with a collective bargaining agreement or CBA. The dismissal may be questioned through the grievance machinery established under the CBA. If the complaint is not resolved at this level, it may be submitted to voluntary arbitration. Number 8, in cases of illegal dismissal, who has the duty of proving that the dismissal is valid? It's of course the employer. That's why it's very difficult to file a complaint also against the employer or to complain about your termination, because of course the employer can always defend itself. Okay, the employer will always create a reason for you to be removed. Number 9, suppose the employer denies dismissing the employee, who has the duty to prove that the dismissal is without valid reason. So the employee must elaborate, support, and substantiate his or her complaint that he or she was dismissed without valid cause. So in the case of Ledesma versus NLRC, but it will really take long. So you have to really provide a substantial evidence in that you were really terminated without a valid cause. Number 10, on what grounds may an employee question his or her dismissal? An employee may question his or her dismissal based on substantive or procedural grounds. The substantive aspect pertains to the absence of a just or authorized cause supporting the dismissal. The procedural aspect refers to the failure of the employer to give the employee the opportunity to explain his or her side. Okay, 11. What are the rights afforded to an unjustly dismissed employee? An employee who is dismissed without just cause and is entitled to any or all of the following. Okay, listen here. So, pwedeng maibalik. Actually, kapag natanggal ka ng hindi naman valid yung reason, okay, wala doon sa just causes yung talagang rason ng pagkakatanggal sa'yo. Okay, hindi naman napatunayan na yun ay isang just cause o under ng just cause. So, pwedeng magkaroon ng reinstatement. Okay, so pwede kang maibalik. Reinstatement without loss of seniority rights. So, ibabalik ka kung ano yung pwesto mo at walang magbabago kung magkano yung sahod mo. Ganon. Letter B. In lieu of reinstatement, an employee may be given separation pay of 1 month pay for every year of service. So, babayaran ngayon ng employer mo. Okay? So, babayaran ka. So, like with what happened to the case of Golden Ace Builders et al. Versus Jose Talde. Letter C. Full back wages inclusive of allowances and other benefits or their monetary equivalent from the time compensation was withheld up to the time of reinstatement. Letter D. Damages if the dismissal was done in bad faith. So, kapag yung dismissal mo talaga really cost you damages also or damage on your end, so pwede ka mag-file ng legal action against the employer and of course, you will be paid for that, for the damages. Alright, So that's all for today. Thank you for joining me for another short lecture video. If you like the video, please don't forget to like and subscribe to this channel. Thank you. Goodbye.